Okay, so now we're back for the ruling in this case against Brian Freedman and the estate of Travis Flores. Travis Flores' spouse, Clement Fiore, acting as his representative. There was a hearing on the 5th of March about this. So Flores' spouse filed the complaint, obviously, and Freedman responded with anti-SLAPP motion and a motion to strike. The reason for the two different parts is the anti-SLAPP would have only applied to certain parts, certain causes of action. And I think the motion to strike was for the remainder. Now, they had a hearing on it on the 5th of March after the full briefing of this. So I've done videos on the motion, on the opposition, the declarations that were attached, and we looked at the actual settlement agreement as well between Travis Flores and Justin Baldoni, amongst other defendants in the original lawsuit. And I've just done Freedman's. It was quite spicy. It was quite funny as well. Reply to the opposition from Clement Fiore. Following the full briefing, there was this hearing on the 5th of March, and the judge decided to take the matter under advisement. Now, remember, this is a new judge because Freedman basically requested that the judge be changed. So that happened. Let's have a look now, because we now have a ruling. Okay. Defendant's special motion to strike is granted in part to the extent described herein. So it's granted in part. Let's look at that. This is not too long, thankfully, so we shouldn't be too long here. The causes of action for invasion of privacy and defamation are stricken in their entirety under California's anti-SLAPP law. However, the three other causes of action for breach of contract, legal malpractice, and breach of fiduciary duty may proceed in their entirety. Moving party to give notice. Okay, so the defamation and breach of privacy claims are gone. But the breach of contract, breach of fiduciary duty, and legal malpractice claims are proceeding. So let's look into why. This action is brought by the estate of Travis Michael Flores against Flores' former lawyer, Brian Freedman. In 2021 and 2022, Freedman represented Flores, now deceased, in an idea submission and copyright case against Justin Baldoni, a well-known director. In that case, Flores claimed he had originated the idea for a film 5 Feet Apart, created and directed by Baldoni. That case settled as a walkaway, i.e., without payment by either side. Now, Freedman, Flores' former lawyer, represents Baldoni in a famous litigation involving Baldoni and the actress Blake Lively. The Lively-Baldoni litigation has garnered worldwide attention. Freedman was asked by the press about the older lawsuit in which he represented a client adverse to Baldoni. Freedman responded by saying, "In the copyright infringement case, I learned what great people Justin and Wayfarer, Baldoni's company, were. I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin's or Wayfarer or any other defendant's part. This only further confirmed to me that Justin and Wayfarer are exceedingly honourable and highly ethical." According to the complaint and evidence submitted by the Flores estate, this media statement and similar statements by Freedman to the press brought attention to the Flores earlier lawsuit, damaging the reputation of the late Flores and causing the estate itself to incur legal and other fees to deal with the press attention. I mean, to be fair, Freedman was asked about the case because it already gained attention. People had already found this case and were kind of linking the two. And that's why Freedman was asked to give a statement. He gave one statement, and as far as I'm aware, hasn't said anything since. We kind of refer to this actually as the Streisand effect, where if the estate of Flores, Clemency had not launched this litigation, much like Lively actually, if everything had just been allowed to settle and die down, it would have blown over. But because, you know, an issue was made, a law, and especially in this case actually where the lawsuit was initiated, people became more and more aware of it, and people were talking about it more, and it went on and on and on. There was a famous lawsuit involving Barbra Streisand, the singer and actress, where I can't remember exactly what happened, but a comment was made, or a photo she didn't like was used for something like that, and instead of just letting it pass, she initiated a lawsuit. Well, then people were talking about it forever and a day. Oh, I remember now actually. There was a photo posted of her home. She was trying to, and she initiated a lawsuit to try and suppress the publication of a photograph of her home. But what actually happened was the unintended consequence of the effort increased public awareness of the information, i.e. the her home, where it was, what it looked like. So yeah, the Streisand effect. And I think that's what's happened here. He has filed a lawsuit because he's had, brief attention, because people have linked this lawsuit with the Flores lawsuit, because both Freedman and Baldoni appear in both. The Wayfarer Studios are not in the Flores original litigation. That is Wayfarer Entertainment, which is a different, it's the company that preceded Wayfarer Studios, which is in the Lively lawsuit. So they are different companies. But Baldoni and Freedman were, the two common factors in both lawsuits, and people were linking them. I have no end of Lively supporters bleating on at me about, how Justin Baldoni was once sued by a dead guy. I mean, they were really, they were that level of disrespectful. And he clearly didn't even look into the case at all to see what had actually happened, what was the outcome. They were just, throwing these statements away, like, using it to point score. And it was on that basis that Freedman was asked about it, and he gave this one statement, and I'm not aware of any other statements. And had Zuri just left it alone, it might have just blown over. But now it's just, it's ramping up. Okay. The estate brought the instant action. The complaint alleges causes of action for breach of contract, legal malpractice, breach of fiduciary duty, invasion of privacy, and defamation. The complaint alleges 3 general bases for Freedman's liability across the 5 causes of action. First, the estate alleges that Freedman committed malpractice, breach of contract, and breach of fiduciary duty in the original representation when Flores was Freedman's existing client. For example, the estate alleges that Freedman advised Flores to settle his allegedly meritorious claim for a walkaway. Second, the estate claims that the media statement and similar statements to the press constituted a breach of Freedman's duties as an attorney to Flores as a former client. Most significantly, the estate alleges that the media statement violated Freedman's duties to his former client because it shared confidences about the representation with the press. Third, the estate claims that Freedman committed torts going beyond his duties as an attorney, specifically that he defamed Flores and invaded his privacy by issuing the media statement and similar press statements. Freedman has now brought an anti-SLAPP motion. For the reasons discussed below, the court concludes that the anti-SLAPP analysis is different as to each of the 3 general bases for liability. First, to the extent it seeks to impose liability for Freedman's actions when Flores was not an existing client, this is a garden variety legal malpractice case, which is what Freedman said in his reply brief. The anti-SLAPP law does not apply at all. Indeed, it would be frivolous to argue otherwise, and Freedman concedes as much. Second, to the extent the malpractice, breach of contract, and breach of fiduciary duty allegations are based on Freedman's breach of duties to Flores as a former client by issuing the media statement, the court finds that the anti-SLAPP law applies, i.e., that imposing liability based on the media statement meets the first step of the anti-SLAPP law. However, because the media statement on its face could reasonably be construed to violate the fiduciary and other duties of an attorney to a former client, and because the statement is not otherwise privileged, the estate has also shown that the breach of contract, breach of fiduciary duty, and legal malpractice claims based on the media statement have sufficient merit to proceed, i.e., the second step of the anti-SLAPP law is not satisfied. Third, the claims for defamation and invasion of privacy cannot go forward at all. These claims are entirely based on the media statement and similar statements to the press. They are thus obviously subject to the anti-SLAPP law in their entirety. They also certainly lack merit in their entirety. Since Flores is deceased, his estate cannot bring a defamation or invasion of privacy cause of action on Flores's behalf. This is an incredibly fair and reasonable judgment, I think. I do think, and I think this is what Freedman was hoping for as well. It's like, I think he knew that the first three causes of action, the fiduciary duty, the breach of contract, and legal malpractice, were probably not going to get thrown out at this stage. But I think he was banking on the defamation and the breach of privacy, which is absolutely fair. I think is absolutely fair. Okay. Court further explains its reasoning below. Oh, I'm going to go through that. In ruling on a defendant's special motion to strike, the trial court uses a summary judgment-like procedure at an early stage of the litigation. This is a two-step process. First, the moving defendant has the burden of establishing that the lawsuit's claims are based on activity protected by the statute. At this first step, the moving defendant must demonstrate that the defendant's conduct by which the plaintiff claims to have been injured falls within one of the four categories described in subdivision E of Code of Civil Procedure section 425.16. As most pertinent here, section 425.16, subdivision E2, E3, and E4 make protected activity any written or oral statement or writing made in connection with an issue under consideration or review by a judicial body, any written or oral statement made in public forum in connection with an issue of public interest, and any other conduct in furtherance of the constitutional right of free speech in connection with a public issue or issue of public interest. Second, for each claim that does arise from protected activity, the plaintiff must show that the claim has at least minimal merit. At the second step, the court determines whether the plaintiff has stated a legally sufficient claim and made a prima facie factual showing sufficient to sustain a favourable judgment. In making both determinations, the trial court is to consider the pleadings and supporting and opposing affidavits, stating the facts upon which the liability or defence is based. So, when the judge here in this says that there's sufficient merit for the three claims to proceed, he's not saying that they have good prospects. He is saying that they have met the bare minimum to continue at this stage. So he's not saying that they are good claims. He's just legal on as far as the law goes. They have met the absolute bare minimum threshold to remain. Okay. Factual history. The decedent, whose estate brought this action, Travis Michael Flores, was a published writer born with cystic fibrosis. In 2012, Flores developed a screenplay titled 3 Feet Distance based on his own experience living with his condition. Flores participated in a television series entitled My Last Days in or around 2016. That's not right. I was sure it was 2019. Hosted by executive producer Justin Baldoni. During his tenure on the series, Flores allegedly shared his ideas for 3 Feet Distance with Baldoni. No, I don't think that's right either. If I was Freedman, I'd be taking issue with some of this because that's not right either. He made a point actually of keeping the information separate from Baldoni. He says that in the original lawsuit. It was Caleb Remington who was also a consultant who Caleb Remington has cystic fibrosis too. And Flores sent his script out to a couple of companies, I think Lionsgate and CBS. Caleb Remington was working for one of the companies that saw, was it Ambry possibly? There's a lot of dependents. I'm not entirely sure who's who, but Caleb Remington was the one who saw the script and then went on to also be a paid consultant for 5 Feet Apart. But this isn't right that Flores shared his ideas for 3 Feet Distance with Justin Baldoni. That's not true. Might be what, I don't know whether that's what Clement Ciuri is alleging, but that's not right. And the date of his appearance on the show as well, 2016, is not right. Okay. Baldoni then went on to direct 5 Feet Apart, a 2019 motion picture officially inspired by the life of cystic fibrosis activist Claire Wineland, who was also cast on My Last Days. The estate alleges that Baldoni stole Flores' script to develop 5 Feet Apart. And that's not right. In July of 2021, Flores retained Freedman and the other defendants, collectively going to be referred to as Freedman, to pursue a federal copyright infringement action against Baldoni and others for stealing the script to 3 Feet Distance. Freedman allegedly filed the action without performing due diligence to investigate the strength of Flores' claim and failed to uncover key evidence supporting Flores' position. Instead, Freedman allegedly concluded Flores' case was meritless upon Baldoni's filing of a motion to dismiss under Federal Rule of Civil Procedure 12b-6. Flores entered into a non-confidential settlement of the copyright action, ending the case with no admission of liability or lack thereof and a waiver of any party's right to recover fees or costs. The copyright action was dismissed on March 29, 2022. Flores passed away on May 23, 2024. In December of that year, Freedman began representing Baldoni in his high-profile litigation against actress Blake Lively. The parties agree that the factual and legal claims asserted in the Lively-Baldoni litigation are unrelated to this action. However, in January of 2025, Freedman made the media statement references above. The estate contends that defendants breached their contractual, fiduciary, and professional obligations by performing insufficient work, providing poor legal counsel in advising Flores to agree to the settlement, failing to disclose a conflict of interest, and failing to maintain and return a complete client file. Ciuri also contends that Freedman's public statements constitute a disclosure of confidential attorney-client communications that undermined Flores' legal position, invaded his privacy, and defamed his character. Anti-SLAPP Step 1. At the first anti-SLAPP step, the question is whether a defendant has met the burden of showing that a plaintiff's claim arises from protected activity, which happens when that protected activity underlies or forms the basis for the claim. A plaintiff's complaint ultimately defines the contours of the claims. The complaint therefore has the primary role in identifying the claims at issue in the first anti-SLAPP step. In analysing whether a claim arises from protected activity, the court is not bound by the labels given to a single cause of action. If a claim for relief is supported by allegations that concern both protected and unprotected activity, the court must distinguish between the allegations supporting protected and unprotected activity and apply the anti-SLAPP law only to the allegations of protected activity. Flores as a then current client. To begin the anti-SLAPP analysis, the court notes that the authorities have established that the anti-SLAPP statute does not apply to claims of attorney malpractice. Thus, where a legal malpractice action is brought by an attorney's former client, claiming that the attorney breached fiduciary obligations to the client as the result of a conflict of interest or other deficiency in the representation of the client, the action does not threaten to chill the exercise of protected rights, and the first prong of the anti-SLAPP analysis is not satisfied. This well-established bar to the use of the anti-SLAPP statute for ordinary claims of malpractice applies whether pleaded as malpractice claim or breach of fiduciary duty or any other theory of recovery. Here, much of the complaint falls squarely within the rule barring the use of the anti-SLAPP law to strike ordinary malpractice claims. The complaint alleges inadequate investigation by defendants in Flores's former action and advising Flores to accept an allegedly inadequate settlement in his idea submission case. There is no basis for applying the anti-SLAPP law to these allegations, which provide the primary basis for the malpractice, fiduciary duty, and breach of contract claims. Indeed, Freedman does not argue to the contrary. While his initial motion is somewhat unclear on this point, Freedman's reply brief makes clear that Freedman does not seek to strike allegations related to Freedman's conduct while he represented Flores as a then current client. Accordingly, there can be no dispute that the malpractice, fiduciary duty, and breach of contract allegations fully survive the anti-SLAPP motion to the extent that they are premised on Freedman's activities while Flores was a current client. Flores as a former client. Freedman also argues, however, that actions he took on behalf of Baldoni when Flores was a former client are not categorically exempt from the anti-SLAPP law. Here, Freedman finds legal support. The case law has distinguished for anti-SLAPP purposes between a client suing his or her former attorney for actions taken on the client's behalf and a client suing his or her former attorney for actions taken on behalf of another client. Freedman points to the following allegations as undertaken, Freedman says, when Flores was a former client, and thus, Freedman says, subject to the anti-SLAPP law. A. Failing to maintain and return a complete client file. B. Failing to disclose a conflict of interest when Freedman began representing Baldoni. And C. Freedman's commenting on Flores's action and Baldoni's character to the press via the media statement. The court agrees in part and disagrees in part. The first two categories, failing to maintain and return the client file and failing to inform Flores of the conflict, are not actions Freedman took solely on behalf of different clients. Rather, these are actions about obligations that Freedman owed directly to Flores and failed to perform on Flores's behalf. These are thus activities that could give rise to an ordinary action for legal malpractice. They are therefore categorically outside the protections of the anti-SLAPP law. Indeed, contrary to Freedman's argument, the only case to address the issue specifically finds that a failure to properly return a client file to a client is an act of legal malpractice, categorically falling outside the anti-SLAPP law. Thus, the allegations concerning client files and a disclosure to Flores about a conflict of interest are not protected by the anti-SLAPP law, and Freedman has not satisfied his burden at the first anti-SLAPP phase as to those allegations. That leaves the media statement and similar press statements. These statements plainly were not made on Flores's behalf or during Freedman's the representation. Shouldn't be the. I think the shouldn't be there. Or during Freedman's representation of Flores. Rather, they were made on behalf of a subsequent client, Baldoni, during Freedman's representation of Baldoni. The media statement and similar statements are therefore not categorically outside the anti-SLAPP law. And since the media statement and similar statements are not categorically outside the anti-SLAPP law, they are clearly and obviously protected by the anti-SLAPP law. These are statements made to the media on a matter of intense public interest. As a long line of California case law recognizes, issues involving celebrities like the Baldoni Lively litigation are topics of widespread public discussion and therefore may be an issue of public interest. Moreover, the media statement and similar statements clearly contributed directly to that discussion. In making the media statement and similar statements, Freedman facially participated in or furthered the discourse that makes an issue one of public interest. These statements were, therefore, under governing California law, statements concerning matters of public interest protected by the anti-SLAPP law. In sum, the court concludes that Freedman has shown that the complaint's allegations concerning the media statement and similar press statements, and only those allegations, fall within the anti-SLAPP law. The court turns to the second anti-SLAPP step as to the allegations only. At the second step of the anti-SLAPP process, a plaintiff has the burden of showing that the claims based on protected activity have at least minimal merit. A SLAPP motion, like a summary judgment motion, pierces the pleadings and requires an evidentiary showing. In ruling on the motion, the court does not weigh credibility nor evaluate the weight of evidence. Instead, the court accepts as true all evidence favorable to the plaintiff and assesses the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. A plaintiff need only to show a minimum level of legal sufficiency and triability. Here, the estate has the burden of showing a triable issue of fact as to whether the media statement and similar statements can be a basis for the breach of contract, legal malpractice, fiduciary duty, invasion of privacy, and defamation claims. The court distinguishes between the different causes of action. It concludes that for the attorney-client related causes of action, breach of contract, fiduciary duty, legal malpractice, there is a showing of minimal merit. For the defamation and invasion of privacy causes of action, there is not. Since the media statement is the only factual basis alleged for the defamation and invasion of privacy causes of action, and since those claims are clearly without merit, those two causes of action are slappable in their entirety. I love that term, slappable. Legal malpractice, breach of fiduciary duty, and breach of contract. Freedman argues that the media statement cannot be a basis for these claims for three main reasons. A, it is a statement protected by the true and fair reporting privilege of Civil Code Section 47D. B, it is protected by the litigation privilege of Section 47D. And C, the media statement did not breach Freedman's fiduciary, legal, or contractual obligations to his former client, because inter alia it did not reveal a client confidence. In the court's view, each of these arguments fails. First, on the record here, whether the true and fair reporting privilege applies is a question of fact for the jury. The fair report privilege confers an absolute privilege on any fair and true report in or communication to the public journal of a judicial proceeding or anything said in the course thereof. In general, whether a privileged occasion exists within the meaning of Civil Code Section 47, Subdivision D, is for the court to decide whether the report of the official proceedings itself is fair and true, provided reasonable minds could disagree as to the effect of the communication on the average reader or listener is a question of fact for the jury. That's fair. I think this is really fair. So what the judge is saying here is, that these are issues of fact, and therefore the jury is the right place, the right forum, I guess, to decide. Okay, here. There is ample question as to whether the report was in fact true and fair. Unlike cases in which the true and fair privilege was found by courts to apply as a matter of law, the media statement does not merely recite the facts of an underlying legal proceeding. Which is what I did say this yesterday when I was reading the opposition, Clement Zuri's opposition. I did say, I can see what he's saying, and I do think Freedman went a bit further than just say, well, this is how the case settled. He did kind of weigh in an opinion on Justin Baldoni, because the fact that it was settled without any liability is not an unusual thing. There are plenty of people who are absolutely, they have done what they are being sued for, who settle at the earliest opportunity. But there are also plenty of people who have not done what they are being sued for, who will also settle a claim. Freedman himself has also done this, because you don't want the public, expense, the time-consuming process. It becomes a matter of public record. Some people don't want that. Like in Freedman's case, it would have affected his career. Well, he wouldn't have had a career, put it that way, had he gone to trial, because it becomes a matter of public record. So by saying, well, this case, the Flores case proved to me that Justin Baldoni was exceedingly honourable, whilst I kind of laughed at the way that Freedman dismissed Claire Wineland's, and it was, a declaration full of hearsay, because she was trying to recant Claire Wineland's words to her. Well, that person's not here now to verify those statements. Therefore, it is hearsay. But also, I can see where this is going. I can see where Clement Zuri is going, like in the sense that he didn't just say, "Well, this is what happened with the case," and we have now moved on, and now years later, I'm representing this person. He went on to say, "Well, that case told me so much about this person and the character," when really that wasn't in the public filings. That is an opinion, and I'm inclined to say it's an unactionable opinion. But that is going to be for a jury to decide. It's an issue of fact. But I can see where the judge is kind of saying, look, you didn't just merely recite the facts of that case. You went beyond. I think he went beyond. Clement Zuri also clearly thinks that he went beyond. And I think this is fair then to let it go forward and let a jury decide. Judge continues, nor does it present basic facts of a legal proceeding with some literary license or mild puffery. Rather, it makes affirmative statements about the merits of both Flores' idea submission case and the character of Baldoni. It does. It claims that Baldoni and his associates were great people and that they did absolutely nothing wrong. Yeah, they are two strong statements, really. They are too strong. I appreciate that he's defending Baldoni, but it cannot just from the from the work that was actually done and how far they got in the Flores case before they settled. He cannot make that assumption about Justin Baldoni that he did absolutely nothing wrong, because they didn't actually get that far into. They didn't do any discovery at all. So he cannot know that. He may, like, and I think I said at the time I was reading the opposition, I think what Freedman's done is he is probably reflected now on the man he's got to know since the Lively case, and he's looked back and gone, wow, this is a really nice guy, yeah. And he's probably reflecting on the Flores case. But I think it would have saved him a lot of a headache if he had just not gone so hard with the statement. But that's Freedman's. That's how he's so successful, is how hard he champions his clients. So I also, wouldn't expect anything less from him, though, and I'm certainly not knocking him for his method of defending his client and speaking out for his client. But I do think it had the effect of, elevating Baldoni, and it could be perceived that he was, undermining Flores's case a little bit, or his opinion, Flores's opinion of his case. I hope that's kind of making sense, though. But I mean, I'm a diehard Freedman fan. I absolutely adore him and the way he advocates for his clients. I just think I think it was just a bad choice of words. But as I said, I think he was kind of caught, off guard a little bit with the question, and was possibly a little bit flustered in his response, trying to strike the balance between, supporting and protecting a former client versus his current client, who were at one point adversaries. So it's not an easy thing to do. And most people would find that difficult when you kind of, just asked a question about it with no warning and no pre-prepared statement. But I do think the judge is making a fair comment here. That, well, this is going to be for a jury to decide. I do. Okay, so he, yeah, all of this is in dispute. The estate has introduced a declaration from Melissa Yeager, who had knowledge of the facts leading to the underlying dispute, and who strongly disputes Baldoni's integrity and character in connection with the film that gave rise to the original litigation. It has introduced another declaration from Clement Suri indicating that Freedman did not interview the key witness in the underlying litigation, and that Freedman failed to consider critical evidence as to liability. While this evidence is certainly subject to dispute and may or may not ultimately be credited by a jury, it is more than enough to establish at least a triable issue, which is, that's fair, as to whether the statements made by Freeman in the media statement were true and fair. Accordingly, the true and fair privilege is not enough for Freedman to prevail at the second anti-SLAPP step. Second, the litigation privilege under Civil Code Section 47B does not apply to the media statement either. That privilege does not protect media statements such as this one. The privilege simply does not apply to press conferences and press releases, of which the media statement was one. Third, contrary to Freedman's argument, there is a triable issue of fact as to whether the media statement violated Freedman's professional obligation to not disclose client confidences. And again, I don't think this is the case, but I can understand that what the judge is effectively saying is that this is going to be an issue for the jury to decide. Freedman argues that the statement cannot have disclosed any client confidences, since the media statement refers only to Baldoni's character and information he learned from Baldoni, not to information he received from Flores. There is a significant problem with this argument. It misunderstands Freedman's professional obligations and the meaning of an attorney's disclosure of confidential information under the law. The relation of attorney and client is one of the highest confidence, and as to professional information gained while this relation exists, the attorney's lips are forever sealed. And this is true notwithstanding his subsequent discharge by his client. Confidential information for these purposes is far broader than matter protected by the attorney-client privilege. It is also broader than matter that is, in an ordinary language sense, confidential. Although the attorney's duty is to refrain from disclosing a client's secrets, the word secret in this context has a very broad application and refers to any information gained in the professional relationship that the client has requested be held inviolate, or the disclosure of which would be embarrassing or likely detrimental to the client. Critically, the duty of confidentiality a lawyer holds to a former client extends even to disclosing material obtained from someone other than the client. The duty applies to all information relating to a client representation, whatever its source. Indeed, it extends even matters of public record that have been communicated to the attorney in confidence and that might cause the client or former client public embarrassment. Thus, in the broad sense, California law forbids attorneys from disclosing client confidences. The media statement appears on its face to violate a client confidence. It certainly appears that in the media statement, Freedman was disclosing confidential information learned in a client representation to the detriment of a former client. Such disclosure would appear to violate the purpose of the California rules protecting client confidentiality. That purpose is, in part, to protect the attorney-client relationship by giving clients confidence that attorneys will not use information gained in the litigation for their personal gain once the representation has terminated. The estate has also put in evidence of damage arising from the media statement, including costs expended to respond to the media interest in the older lawsuit. At minimum, therefore, there is a triable issue of fact as to whether the media statement violated Freedman's contractual, fiduciary, and legal obligations as an attorney. Fourth, while Freedman raises the argument, he cites no cases establishing that the foregoing limitations of disclosure, which impose stricter professional obligations on attorneys than the limitations that apply to ordinary citizens under the First Amendment, would not apply merely because the media statement might not constitute actionable defamation under ordinary on-the-record here First Amendment standards. To the contrary, the law is clear that a lawyer's right to freedom of expression is modified by the lawyer's duties to clients. Okay. So that's interesting. Then we move on to defamation and invasion of privacy. By contrast, the defamation and invasion of privacy claims lack merit entirely. Deceased persons and their estates do not have a cause of action for defamation, nor do they have claims for invasion of privacy. That claim, as well, dies with the person and cannot be asserted by an estate. Here, the only basis for a claim of defamation or invasion of privacy is that Flores was defamed and had his privacy invaded by the media statement. Although the estate's administrator, Clement Sciorri, has also brought the action under his own name, there is no allegation that the media statement or similar press statements defamed Sciorri individually or invaded Sciorri's own privacy, nor does it appear it could be. There is also no basis for the defamation and invasion of privacy claims beyond the media statement and similar statements in the press. These two causes of action, therefore, are entirely subject to the anti-SLAPP law under the anti-SLAPP prong 1. They entirely lack even minimal merit under anti-SLAPP prong 2. Accordingly, these two causes of action fail completely. Okay. Let me just... I want to pull something up because I'm going to go through it at the same time. Is this it? No. All right. So, allegations to be stricken for the reasons stated above. The court strikes the fourth cause of action, invasion of privacy, and the fifth cause of action, defamation from the complaint. Now, Freedman also had evidentiary objections, which I've got. Here. So I'm going to go through these just because they have. I'm just going to go really quickly through them actually, but they've all been sustained. Yeah, they've all been sustained. So 1 to 7. Objection 1, paragraph 5, line 1, page 1, lines 27 to 28. So these are statements, right? Freedman initially took on the federal case, charged Travis and me a large amount of money up front, then filed a complaint. And he's saying this is not relevant. And the judges sustained that, which means he agrees. Objection 2, paragraph 5, page 1, line 28 through page 2, line 4. When Freedman received the opening motion to dismiss from opposing counsel for Justin Baldoni and the other defendants, he immediately advised us that Travis's case had no chance of success and should be promptly dismissed. Brian Freedman's behavior was strange. Now, when I read this, I was like, what use is that in a legal filing? Like, and I found quite a few things that Clement Ziori put in his declaration problematic, given that he is an attorney as well. I thought it was quite emotive, which I do understand, but it felt a bit like he was just taking shots almost. But the judge has agreed it's not relevant to anti-SLAPP, and also improper argument. So Ziori's testimony that Freedman's behavior was strange constitutes impermissible argument. Judges agreed with that. Objection 3, paragraph 6 in its entirety, right? So what this says is, Attorney Freedman next prepared and told Travis not only to sign a full settlement, under which Travis received absolutely nothing, but then also instructed Travis to sign a comprehensive release of any and all liability to the defendant. Attorney Freedman did not bother to interview the key witnesses to Travis's case. On February 17, 2021, Travis emailed Brian Freedman regarding Melissa Yeager and information to Travis's copyright infringement claims. I obtained this email from Travis's email account. It's a true and correct copy, and a true and correct copy is attached here to as Exhibit 1. So he's objected to this for multiple things. Firstly, relevance, right? Testimony is not relevant to anti-SLAPP. Secondary evidence rule. So the testimony purports to describe and characterize a settlement agreement that is before the court as Defendant's Exhibit 2, and a pleading that is before the court as Defendant's Exhibit 5, each of which is a writing that speaks for itself. Okay. Legal conclusion and argument. Declarant's testimony regarding the purported relevance of unidentified witnesses and materials that Travis Flores purportedly sent to Brian Freedman is an impermissible legal conclusion and argument, which is true. He's placing, well, you should have gone and spoke to this key witness. And he is making a legal conclusion by suggesting that the witness is key. Lacks foundation and personal knowledge. So the declarant fails to lay any foundation, which you've got to do, or basis of personal knowledge, his testimony, that Freedman failed to interview witnesses and that any of those witnesses were key to Flores's case, or that Melissa Yeager and the unidentified information was relevant to Travis's copyright infringement claims. So he needs to explain why. He needs to explain his personal knowledge, right? Well, this is how I know this. And then, basically offer a foundation to explain the basis of his personal knowledge. And he did not do that. Failure to authenticate. Declarant also fails to lay any foundation for his testimony that Exhibit 1 is an authentic reproduction of an email obtained from Travis Flores' email account. Again, what he said in his declaration, Clement Ziori, he said this is a true copy. but he does not lay the foundation that it is an authentic reproduction of an email which was obtained from Travis Flores's email. And we saw that in the deposition, like how many times was someone who was sitting for a deposition, we'll say Justin Baldoni, he was handed a text message. Do you recognize this? Do you remember this? And he had to, say yes, basically, before they could move on and ask him questions about it. So he had to confirm that the text messages, he remembered them, he could authenticate basically that they were true, they were correct, they hadn't been tampered with. If he had said, no, I don't remember that, or there were several messages missing from this, then that would have been a problem, and the question, he would not have been questioned on it then. But yeah, and it applies here as well. Where he's attaching exhibits, everything has to be authenticated. So that was also, those objections were sustained. Now, objection 4. I won't go, I will probably just do like 10 of these. There are a lot, there's 22 pages. I won't go into all of them, but they were all sustained. If anyone wants me, I'll do 10, and then if anyone wants me to continue, I'll do a separate video then. I think that's the fair way of doing it. Objection 5, paragraph 17, its entirety. After reviewing the limited client file produced by Freedman's law firm, it appears that on March 29th, 2022, Brian Freedman sent an email to a Bloomberg reporter in which he quoted Travis and relayed the reasons behind the dismissal of the federal action. A true copy of that email is attached. Again, relevance, secondary evidence, and failure to authenticate. And that's been sustained too. Objection 6, Exhibit 2. So to the declaration, Exhibit 2. So this is, Exhibit 2 is the email from Brian Freedman. That statement on behalf of Clement Suri. He wants it excluded. Why? It's got no bearing on any of the issues raised in the anti-SLAPP and is therefore not relevant. And Judge sustained that. Paragraph 8 in its entirety, page 2. Our family's next major shock occurred when we learned that attorney Brian Freedman had jumped over to begin representing Justin Baldoni in a litigation involving actors Blake Lively and Ryan Reynolds. And I laughed at the point where I was reading this on the video and kind of scoffed. I was like, well, he hardly jumped over. It was 2.5 years past. It wasn't like he literally got Travis Flores to settle this case and then went, right, Justin, I'm ready. Which is how this is being presented, and I had an issue with it. And I'm glad that, I think I did say, I hope Brian Freedman takes some issue with some of this. Now, at the time, I hadn't read this. I'm only reading this now, actually, for the first time. But I'm glad that he did, because it's problematic, and it's a bit sensationalized. Our family's next major shock. 2.5 years later. Travis Flores isn't even here to be shook by this. It's just ridiculous, the language that's being used here. And it was objected to for relevance, because it's not relevant, and legal conclusion and argument. Declarant's testimony jumping over constitutes impermissible legal conclusions and arguments. And the judge has gone, yeah, I agree. Basically, he has sustained it. Paragraph 9 in its entirety, page 2. We did not learn of attorney Brian Freedman's shift in loyalties. Again, this is another moment where I had a little giggle, because it's just ridiculous. We did not learn of attorney Brian Freedman's shift in loyalties from attorney Freedman or anyone else in his law firm, as one would expect under the rules that regulate attorney conduct in the state of California. Instead, after Travis's death at age 33, I mean, why is his age relevant here? Our families and I learned about Freedman's conduct from the media and the reporters who began calling me and my families during the Baldoni Lively Reynolds media storm. So Freedman said, well, this is not relevant, and judges agreed. Legal conclusion and argument. Declarant's testimony suggesting that defendant's representation of Justin Baldoni constituted shifting loyalties and or violated the rules that regulate attorney conduct in the state of California constitutes impermissible legal conclusions and arguments. Judges agreed with that. Improper opinion testimony. Declarant's testimony about what one would expect under the rules that regulate attorney conduct in the state of California is improper expert opinion and unqualified lay opinion, which is fair. Now people are going to say, but he's an attorney too. I mean, he is. But in this situation, he is an individual, and he is not offered up as an expert, so you cannot give an expert opinion regardless of his background knowledge. Lacks foundation and personal knowledge. Declarant fails to lay any foundation or basis of personal knowledge for his suggestion that defendant's representation of Baldoni violated the rules that regulate attorney conduct in the state of California. Again, I agree with that. It's a throwaway statement, like it's an opinion, but when you put it into a legal filing, it is designed to make a statement as to fact, and it can't do that. A statement like that cannot do that. Hearsay. To the extent the testimony purports to recount or summarize out-of-court statements in telephone calls or otherwise, it constitutes hearsay that does not fall within any exception. Judges overruled all. Not overruled. He has sustained all of that. Objection 9. Paragraph 11 in its entirety, page 3. Due to the volume and persistence of those press inquiries, I was compelled to retain legal counsel to protect my own reputation and to safeguard the interests and voice of the estate of Travis, for which I serve as the court-appointed administrator. So, lacking foundation and personal knowledge, he fails to lay any foundational basis of personal knowledge for his testimony that retention of legal counsel was necessary or a legally cognizable way to protect his reputation and to safeguard the interests and the voice of the estate of Travis. I don't think that's unfair. He hasn't explained why he needed to retain counsel because he was contacted by the media. He hasn't said why that was necessary. There's no reason why at first instance he couldn't have dealt with that himself, even if he wasn't an attorney. Do you need to retain counsel for everything like this? I'm a bit dubious because it just seems like you got to mitigate your costs, and it feels like he didn't, and he rushed straight to retain counsel when it doesn't look like it was actually necessary at that point. Because I didn't see the estate, anyone on behalf of Travis Flores or his estate, come out and offer a counter statement. So I'm not quite sure what the legal counsel were doing at the time of the statement, because this lawsuit wasn't filed until was it like October, November? But we're talking about a statement that was made to the press back in January last year. So for all those months, what were the counsel doing? Hearsay. To the extent the testimony purports to recount or summarize. Yeah, okay, hearsay. I do agree with that. Okay, so objection 10. Paragraph 12 in its entirety, page 3. I've incurred significant expenses as a direct result of Mr. Freedman's defense of Mr. Baldoni in the press while addressing in his own way his representation of Travis. I believe Mr. Freedman could reasonably have anticipated that the lively Baldoni action alone, but also his role as Justin Baldoni's opponent's attorney in the copyright action, would draw press scrutiny. Yet Mr. Freedman took no steps to protect me, my family, or the estate from the resulting reputational and legal consequences. So the objections are obviously relevance, legal conclusion and argument. So that's on the basis that declarant's testimony suggesting that Brian Freedman did not take appropriate steps contains impermissible legal conclusions and arguments. It's fair. That's true. It's lacking foundation and personal knowledge. He's failed to lay any foundational basis or personal knowledge for his testimony about what Freedman could reasonably have anticipated or what steps Freedman took. Again, I fully agree with that. And hearsay. The judge has sustained that. Okay, so I'm gonna leave it there. If anyone is interested in the rest of these, there are I think there are 26 objections. We've gone through 10. So if anyone is actually interested in a separate video doing objection 11 through to 26, I'm happy to do that. But it's just a little favor. But I find these things, I don't know, I might do it anyway, like, actually, because I enjoy going through these bits. It's quite funny, and I find this bit quite snarky, actually. But I'm going to leave it there because we're at an hour now anyway, and I hope you enjoyed this. And I will do a follow-up actually with the continuance of the objections because I just think it's amusing. All right, guys, take care.